to sort of see who to invest with. And the more experience you have, the more sort of track record you have, that's better.
So in a way, the way I can gauge from what you're saying is that you would be more giving preference, so to speak, to the experienced or more seasoned fund managers, if I may put it that way, rather than to first-time fund managers who may not have that kind of a track record. Would that be the approach from your end?
Yeah, so we're not saying that we will not invest in first-time fund managers. Let's say it's a spin-out team which is done investing all its life and is now spinning out of a larger fund. We'll be happy to look at them because I think they have the relevant experience. But yes, if it's a first-time fund manager who has no investing private equity experience, who has no fund management experience, it'll be difficult for us to look at them at this point in time. Having said that, as I mentioned, it's a long-term game. It's a 10-year fund, 5-year investment period. So we're happy to look at these funds over a period of time.
All right. Okay. Thanks, Neha, for your inputs. Over to you, Ashley and Sudhir. As a leading private equity and venture capital fund, what do you think the near future holds for new fund launches? Will the target fund sizes reduce, or will the GPs delay their short-term fundraise plans? I can start with Ashley first.
Sure. So I think, as Neha said, I think this is clearly something which is unprecedented, the crisis that we are in. That being said, we have seen other situations where there have been crises, right? So we've seen how those environments have behaved. I think there's no telling that this will be very similar to that. It's probably going to be significantly worse than anything that most people have seen. The good thing is that, the belief is that it's not a permanent change. Right? So it's a temporary setback, whether you can say it's 6 months or it's 12 months or it's 18 months. And as Neha said, we are in the business of, it's a 10-year business. So it's 5 years of investments and 5 years of so I think, opportunity will continue to be there. We as investors, certainly to the points that Neha again said, we are looking at good quality deals. The pipeline is actually pretty robust. We are spending, 8 hours investment committees versus, 3-4 hours that we would do typically a week. So there's a lot more activity. So I think, there definitely is the opportunity. That being said, to your direct point, I think someone who's in the market today and is in the process of raising a fund will find it a little difficult for a variety of reasons. I mean, I would expect investors to want to sit back and understand this a little better, to see, the overall impact. There are other priorities today. So people will not be desperate to deploy capital. And that's my sense from an LP perspective. The few investors that we've interacted with have said, look, people are very, very interested, want to continue to do it. But in the short term, in the next 3 months, 6 months, I don't think you'll see too many decisions being made. So if you're in the market to raise capital today, I think clearly that will take a pause. If you're fortunate to have raised capital, as some of us have done, maybe a year or 2 years ago, and you're sitting on that capital, I think it's clearly a huge benefit, a huge advantage you have relative to people who are nearing the end of their investment period of their prior funds. So it's a temporary setback. To summarize, I do believe that we're not going to see a radical change in the way private equity funds operate, but there will be a short-term disruption that one will need to sort of time.
Okay. One important point you made, Ashley, was that you are these days spending more time on the IC. So just wanted to understand a bit more about it. So is it because of that you are now flush with new opportunities, or it's just that you're now making more in-depth analysis of whatever opportunities are there with you to make sure that you are, asking more questions and, checking more things which you otherwise were not doing till now. So what is the change?
Sure. So I think we're also spending a lot more time on our portfolio itself. right? So there are 15 to 17 companies in the portfolio. One is you're delving deep in, which you do typically, but not as deeply right now, because you're trying to do an analysis to say, how much cash do they have? What are their initial requirements? What's the short-term hit for them? What's the long-term? A sales cycle is going to come back. Are there things you can do? Are there, people are asking questions about what do we do with our employees? Do we cut salaries? Do we give them layoffs? Do we go re-incentivize them, give them ESOPs? So there's a whole variety of questions you're spending on portfolio. So that's taking. I think in terms of opportunities, as earlier, I think the analysis is obviously going to be a little more in depth in terms of understanding the impact of COVID. But frankly, if you've got to make a decision in the next 4 weeks or 6 weeks, right, you will not really know. Right? I mean, we're looking at a couple of consumer businesses, which we know the deal or the timeline right now is the next 3 weeks, 4 weeks. I don't see us reaching a stage where you can have a good perception of what's going to happen. I think you can do your analysis and understand it a little better, and you got to do that analysis. There's no getting away from that. But you will not know all of the answers. And so at some level, Neha's point is absolutely valid. You would go for high quality entrepreneurs, high quality businesses that have the capability to overcome a number of challenges regardless of the environment. Right. And so you would hope that those kind of managers will fare well in situations like this. So that's the additional time that we are spending, on internal portfolio companies, as well as, I guess, to some extent, on new opportunities.
Okay. Thanks, Ashley, for those insights. Sudhir, over to you. What are your views? How are you navigating the present times? And whether you see this as opportunity, or you would hold back on your proposals, or you will just go ahead and screen the proposals that come your way, and just be more careful in terms of what kind of screenings that you apply.
I think this situation today, the fourth downturn I'm going through, is very different from the past, and I'm mentioning because I think this is going to be long term. There is a new way of business which will emerge out of this. And the reason for that is very simple. In this crisis right now, there is not a single business which has not been touched, unlike the other crisis. I'm saying not a single one. You take, and I'm a tech VC, so from a tech VC point of view, there are tech businesses, there are non-tech businesses, there are semi-tech, omni-channel businesses. If you take any business which had a logistics angle to it, or had a physical gathering coming into a store, or etc., all those businesses have not tapered down. They have gone from a pinnacle to zero in a matter of 1 or 2 days. That is something which no entrepreneur and no VC has seen before, to my mind. At least I have not seen businesses go down from a pinnacle to zero within a day. Okay, so effectively, that is what VCs like us are talking to our entrepreneurs and saying, how do we now do a strategy to get out of this? Okay. Now, by the way, the reason for this is very important. I'll come to new LP commitments a little bit later, but this is going to be having a bearing on them also. Is new businesses, existing businesses which now have to come out of this, their business model, their revenue model, their product or services, to my mind, is not going to be the same. Because if it is the same, it is going downwards. It is not going to go stay stable. And because we don't, either due to regulation or due to a massive change in consumer insight, consumer behavior, or the operational side of it, including behavioral changes like working from home as an example, they are not short-term changes. They are very long-term changes. And I won't be surprised that, if businesses don't change, and I won't be surprised if governments don't change. So to that extent, it's very important to take a view that, look, what is the impact of this, okay, and how it will come out. Business plans coming back. I've seen business plans coming back and saying, I think I'll come out of this in the month of May. And somebody coming out and saying June, and somebody coming out and saying July. Everybody has to now go through the cycle to determine what the impact on business is going to be. So investors, what are we doing? We I mean, we have done intensive 2 cycles of stress tests on our companies, which is a capital stress test, which is, I think, as Ashley mentioned, how long the runway is. And secondly, in terms of business stress test, what is it that needs to be changed in a very fast manner to make sure the company, A, survives, B, grows. For instance, at least half our companies have gone through introducing rapidly new products, new services, in some cases tweaking the model. In some cases, they have shut down existing businesses completely and gone into new businesses, many of them digital in nature. So if all this is happening simultaneously, then when we look at a new transaction, we will also want to see how the firm which we are looking at, the company, the deal which we are looking at, how is that changing in terms of the new environment which is going to be there for the next. And to that end, we'll also watch. We'll say, hey, we can't figure out, neither can the entrepreneur figure out in a month or 2 or 3 months. Maybe it's a good idea to just wait and see what happens. As far as new LP commitments are concerned, to my mind, they will go through the same cycle, okay? Because they will follow the GP and they will follow the entrepreneur and see what happens. So to that extent, I think decisions are going to be stretched out. Yes, because many of the LPs, have been with us for many funds, their decision making could be, people like with experience or with track record could get some benefit of doubt because they've been through it earlier. But fundamentally, every decision is going to be stretched out. There is no question about it. And it is a long haul here. This is not going to be somebody coming up and saying, I think it will end in 6 months. I think it will end in 9 months. Because actually, to my mind, nobody knows. To my mind, this is a new way of working, which all of us will now have to adapt to. And, this new way, none of us have seen earlier overall. There are many silver linings in almost, I would say, 35–40% of our companies have launched digital products, which are, live at home fitness, nutrition, etc. New products which are going to be in the PP space. People have come out with those weeks flat. So I'm actually seeing on the positive side, agility, innovation, which I haven't seen before because there's a survival issue here. So that's my view.
Okay. Thanks, Sudhir, for that. Tejesh, I'll come back to you in a minute. Just before that, I'll make an announcement for the attendees here that we are opening a poll question for everybody to vote. And then once we have heard Tejesh in terms of his views on this topic, we will announce the poll results. Yeah. So Tejesh, coming to you. So you interact with a lot of fund managers on their fundraise plans. What is the general pulse amongst them that you're hearing?
Hey, thanks, Suneet. Hi, everybody. See, look, it was good to hear Neha, and from a GB perspective also, so LP GB perspective we have got, and it's good to see that it's going to be a near-term sort of a pain, and over the period of time, because these are all longish funds, the things will be better sooner. So see, look, coming on to the fundraising atmosphere as between a lawyer negotiating on behalf of GPs, I of course do watch the strategies and various success factors closely. So I can see some common underlying factors still helping GPs raise money, and I'm sure this will help getting them raise money even post COVID era, right? So now, as rightly put by Ashley also and Neha also and Sudhir also, for instance, the established funds with a track record of generating returns for their LP are better placed compared to the first-time funds. Since having an existing LP base definitely gives you an edge in these testing times, right? So of course, this comes with the caveat that despite a good track record, the large re-up, right? So wherein investors in previous funds elect to invest again in the success funds, even in well-performing funds, as I'm currently seeing, may not be necessarily be available, purely because LPs may have reduced their allocations, or as he has pointed out, there is a wait and watch strategy, right? There are deferred decisions. So things may also have changed in context of allocation to the sector, to the strategy, to the region, right? As everything may be on a wait and watch mode, at least for next or two to come, because purely on account of the changed circumstances. So of course, I'm not denying that. What I'm also seeing is that a few sector focused funds, right? Because if you look at consumer or you look at healthcare, of course, so there are funds out in the market and who are still raising a fair bit of money, right? Because LPs will also bet on the strategy, or even near term, if these look good, LPs are going to bet on these fund managers because there are good, attractive valuations on card. Similarly, you would see a lot of queries being raised that do the fund managers need to come out the special situations fund, right? You see distressed funds, or you may also see like real estate funds, which people will see there are throwaway valuations, so it's a good time to raise them. So I mean, there are several factors in play right now, and yes, challenging times for GPs are definitely, but hope it's only for the short term.
Okay. Thanks, Tejesh, for your insights. A related point on the recent change where the government has issued a press note last week amending the consolidated FDI policy of 2017. The timing of that definitely appears to be directed towards China. But since we have the fund managers here, how do you see that the fund manager should read this development, given that there doesn't appear to be any notification or any changes to the FEMA regulations per se?
No, see, look, the government intent behind all these steps is good because they don't want India to be available throwaway valuations to Chinese investors, and there are other issues, of course, which you can't expressly talk about, right? But see, in absence of the FEMA notification, what we have right now is only a press note, right? But which creates multiple confusions on several counts for the funds. And I'm talking about funds, both funds which are alternative investment funds based in India, and even on the offshore funds which are like pure FDI vehicle investment allocations in India, right? So funds, for instance, both Indian and offshore with Chinese investors will face classic questions in times to come, and like already facing it. Dozens of queries have already come from the reporters or from a lot of clients that how do we deal with this, right? So for an India fund, it may not be able to issue fresh round of units in the new closing if there are Chinese investors who are directly investors in the fund, right? Because then that can get into a government approval issue because it's classic FDI into the India fund, which otherwise is available under automatic route, but can now get shifted to government route. Now again, for a classic offshore bound, India bound FDI fund, it's not pretty clear that from a beneficial interest perspective, are you looking at a significant beneficial owner who is a Chinese investor, and that can create a concern? What is the number of Chinese investors which can create a concern? So this is still not clear because the press note will still use the term beneficial owner. Is it a SBO? It's a beneficial owner. What rules are going to apply? I think it's very pertinent that FEMA notification clarifies all that. And again, you have a classic Hong Kong versus China issue, right? Because this one query would have come like n number of times since morning that will Hong Kong fall under the restriction? So when you're talking about the bordering countries, the classic debate is because Hong Kong being a special administrative region controlled by the People's Republic of China, for instance, will it fall under the restriction? Not because you have like billions of dollars coming from Hong Kong itself under FDI policy. So even before the shift goes to the FPI policy, because this all started from the classic HDFC limited issue in which the Chinese investors were increasing stake and it got into limelight. But before we go there, and that's the SEBI domain, but right now we have a quick issue on FDI in hand. See, as far as India is concerned, it treats Hong Kong and China very separately from a political, legal, FDI computation purposes that way. So hopefully Hong Kong is out of it, but press release will throw you a lot of challenges. It will also say the citizens of China will be falling under the restriction as well. Now, I don't want to get into the nationality law and citizenship laws of China because they are very complicated when the applicability comes on Hong Kong investors. So it's always better that you don't get into those interpretation issues, and when the FEMA notification is out there, these Hong Kong, China, all these aspects are well notified. The beneficial ownership aspects are well notified, because otherwise you are getting into a lot of Chinese investors exercising their excused rights under the fund document. So that's my 2 cents on it.
Right. Thanks, Tejesh. So let's announce the poll results. We can end the poll.
Yes, can I just comment on that? One comment. Yeah. I think as Tejesh mentioned, absolutely, governments obviously will do what they need to do. I do hope that there is a big realization, which we have found at least, that there is capital available in India. Okay, uh, while negative regulations or restraining regulations do come up, there is capital available. We've been raising 50% of our fund from India. I do hope that government also loosens up and rectifies situations where the gap which is partially there for, let's say, Chinese investors being restrained is met through Indian capital. There is Indian capital available. There is Indian capital available in India in terms of pension funds and insurance and family offices which are there. And there are certain constraints under which they operate which are not equal to perhaps public markets or international. And that those representations have been made. So while the restraining stuff is being done, I do hope that the enabling stuff is also done to enable Indian capital to come in a big way, because there is a lot of Indian capital.
Yeah, point well taken, Sudhir. So just announcing the results of the poll on your screens. So the maximum voting is towards information technology being the space which will see a lot of traction going forward.
So it's 54% you have, right?
Yeah.
So can you announce, like, Suneet, out of
So
the
consumer
sectors you have?
Yeah, so for consumers, consumer durables and consumer sector overall, it's 27%. BFSI, it's 12%. Information technology is 54%, and industrials is 8%.
Interesting.
Yeah. Okay. Thanks to all the attendees who participated in the polling. So coming to the next topic of our discussion. So we come to the very interesting topic of how there will be changes going forward so far as LPGP negotiations is concerned, and what level of communication will now happen between the LP and GP. So Neha, here is my first question to you. With the current backdrop, would anything materially change in the nature of rights or terms negotiated by LPs with the GPs? If yes, what would those be? You can just enumerate those.
I think a lot of it will depend on the kind of capital that is coming. Right? I think if it's very long-term capital, patient capital, your pension funds, foundations, there I think you will not see any significant impact. If you look at capital which is invested into, let's say, listed markets, where the underlying theme was to invest more in pipes and listed companies, there you may see some sort of triggers, some sort of rights or terms around fall in market value, valuations, etc. But inherently, if you look at, has the nature of the industry changed? No. If the fund is primarily investing into unlisted companies, I doubt if there'll be any change in terms of. We are looking at a couple of funds right now. We're in the negotiation stage. I don't think COVID is impacting the negotiations. I think the only change that I can see is more information request. If a situation like this arises, if something like this happens, then will the LPs be able to sort of get more information? I think historically in the past, I have never seen a situation where the GP not share information if he has information, because this is a long-term relationship, and communication is always key. Most GPs, at least in the last few years, have matured in India, and we see that that's never an issue. 10 years ago, yes, that was an issue. Today, I don't think that's an issue. So apart from information rights, I doubt if there'll be anything else the only one more thing could be if, let's say, there's a 5-year investment term, fund has just raised money, and if you don't deploy your capital for X number of years, let's say 2 years or 2.5 years or 3 years, then as an LP, I have committed my capital and I'm not seeing it work. So maybe that's one thing that as an LP I would be concerned about. We understand that there'll be a delay in investing and there will be a slow pace of investment, but it should not lead to inaction on the GP's end, because there is so much of uncertainty. And if there is, no problem. we're happy to relook at the commitment because as an LP, we also have our own equity sort of lines. We have to worry about our cost of capital. I think that's the only thing that I can see which will change.
Okay, all right. Yeah, so I think the undertone seems to be that the information rights will increase so far as the ask from the LPs is concerned. Good. Okay. So Sudhir, my question to you is next one. Do you see a pressure on the commercials, that is the fee and the carry terms in the future fundraisers?
Well, future fundraisers would mean, a year, 2 years, 6 months down the line. I think it depends on the LP and depends on, I think it also depends on what is the extent of older LPs forming in the new fund share of capital. In our case, it's 90% overall. And so to that extent, I think, that's something which it's crystal ball gazing, which is very difficult to do. But we have found, without exception, LPs absolutely supportive. I think the trick to that, or the essential element Neha mentioned, is very simple. The communication as to what the GP is doing on the ground is very, very important. Our cycle of communication with all our LPs is now between 1 in 2 to 3 weeks overall. And some of them, of course, come back and say, hey, I need clarifications and etc. It's at multiple levels within the LP, because LPs, some of them are family offices where you reach top, and some of them are institutions where different layers are there overall. So very difficult to do crystal ball gazing in the market space. But I think broadly speaking, if it's a first-time fund, terms will be heavily negotiated. If it's an established firm who has a phenomenal track record, and most important to me, what matters is if the team is at risk overall. The teams being stable in this scenario are very, very important, because venture and private equity is not taught in India schools. It's tribal knowledge. It's learned in the corridors. It's learned every day in the morning when you go and sit with the entrepreneur and the regulator and the lawyers and the LPs as such. So it's very different. Crystal gazing, but negotiation on fees could be definitely there if first-time fund managers come on the job now.
Okay, all right. Actually, your thoughts on that same point? Any pressures on that?
Yeah, no, I think it's similar to what both Sudhir and Neha have said. I think we don't see any reason for commercials to be significantly changed or changed at all, frankly, because as long as you're sticking to the mandate, if obviously you're changing the mandate, then it's a very different cup of tea. And I agree with Sudhir. I think the only situation could be where you offer a sweetheart deal. Certain funds have this policy of getting in 1 or 2 investors early who sort of backstop the fund and they extract a sweetheart deal typically. I would see those sweetheart deals getting more expensive. We've not really done that, but I know certain funds have that and offer that. I would imagine where someone is 1 or 2 LPs are supporting them in the initial days, they will extract their pound of flesh, and that I guess they will look at it as some kind of a return on their higher risk that they are taking and backstopping a fund to help someone get started or raise a new fund. So other than that, I would imagine most things should be the same. I think communications, both Sudhir and Neha have touched upon it. I think that is going to be extremely important. I don't think LPs ask for specific information rights other than their questionnaires, etc. So there are 2 types of communications. One is this unsolicited, which investors send you their checklist saying, what's the health of your portfolio? Is there significant amount of leverage? How are they thinking about things? That's normal. You'd see those checklists becoming a little more deeper in this time, and we've seen that. And then there's the other part, which is initiated by the GP. Seeing that, and we've had few communications with our advisory board, with all of the investors of our fund on a call, through emails, and we've seen other funds do it as well. So you see a lot more of that. I think in times of crisis, it is definitely better to over communicate. So there'll be, you know, the frequency of communication is significantly higher than in normal times. And I think it's necessary and important. It brings out the transparency in the way you're thinking about it. You will not have all of the answers, but at the same time, I think as an investor, it's heartening to know that your GP is focused on certain areas, and we solicit feedback. You know, we solicit feedback, you know, in terms of what's happening globally, right? Are there things that a GP in Brazil is doing that we should be thinking about? Because this crisis may have, you know, the same sort of questions that need answering regardless of geography. So it's good to have that communication with LPs. I think so. It's not a one-way street. I think we see that we are learning from the experiences that our LPs are sort of able to relate to us. So I think that is an important change that we see happening in this situation.
Sure. Thanks, Ashley. Tejesh, over to you. Which legal terms do you believe are being negotiated the most, and where do you see the maximum resistance from either sides? How do you see the future negotiations between LP and GP shaping up?
Hey, sure. Thanks, Suneet. See, look, negotiating LP GP contracts always involves a fine balance between preserving the LP rights without materially curtailing the ability of the GPs to operate the fund and provide handsome returns. That being the primary reason for entering into those contracts and why LPs are investing in first place, right? But frankly, I can see some of the aspects are being negotiated more. They are gaining more significance, and I think they may be more critical in times to come. And we'll see a few negotiations, of course. So I can obviously share a few. For instance, as Neha had very rightly pointed out, that we are seeing more and more institutional LPs negotiating the co-investment rights more rigorously, right? And in fact, I've come across quite a few funds in which the key requirements from the LP is that I want a good co-investment right? Because they are betting on fund manager. They're very confident on the fund manager. So now it's debatable whether they will pay a fee or a carry on the co-investment deals or not. That's entirely from my discussion. But the co-investment rights are being negotiated heavily, and I think they will be given more significance, is what I can once see. I would give high priority to the disclosure and transparency norms. I think the panel is unanimous on that no GPs will hide any information, right? If they have the information available, they will be more than happy to share the same. I think there can be more trigger points, more disclosures, and more transparency, which can be expected from LPs in times to come, right? Accountability, right? Not like many funds have the ESG norms, wherein particularly if DFIs are not there, for instance, voluntarily funds may not put ESG, but I think the environmental social governance norms with the changing times, I think they will gain good significance, because there are some case studies which will suggest that funds which follow ESGs in these times, obviously the returns will be better and they will be more transparent and sound from a governance perspective, right? And we all have those classic clauses on change of managers for cause, without cause. Keyman clauses, they are all being heavily negotiated, and that's what lawyers on both the sides spend half of their time on, and what constitutes cause and what won't constitute a cause. I think they have always been negotiated, and that's gonna be a constant. I don't see things changing there. I think one key thing which is on the composition of fee, because we have a lot of innovative structures which have been done in the past, because with cost increasing on the fee, because ultimately it's going to be a cost where neither LPs are going to bear it, or either GPs are going to bear it, or both of them are going to share it. So more innovative which can put less load on the fund, put less costs. Actually, I think they will be the need of the hour, and Subbu would be the best person, of course, because that involves a lot of tech structuring. So I think you will see that happening more and more. A lot of negotiations we see are happening not only on the management fee, of course, that thing will change, but what about the other costs, right? Because there are extraordinary expenses, there are litigation costs, there are broken deal expenses, right? That's one thing which is always negotiated the most. And in these times, when deals may fall off, at what stage does the manager bear out of his own pocket, or when does the fund bear it? I think that I can see more and more the open points which have been there, even if you have a cap and you say it's on actuals, but what all you can charge, I think LPs want a very clear sort of a set of costs which can be attributed to the fund, right? So these are the basic points I believe are being negotiated very heavily right now, and a few of these things will see even more rigorous sort of negotiations. I think one more point is on the subsequent fund launches, because I've started seeing that 70% clause once you are deployed, or you have funds reserved which will be deployed at some point and you can come up with your follow-on fund. I think there's a lot of stress which will go into the quality GP timing, which has to be devoted on these deals, because from a conflict perspective, how much deals you allocate to the next round, to the previous fund. So quite a few of these aspects, I think we'll see a lot of discussion and are seeing discussions.
Thanks, Tejesh. Subhu, the next question is for you from a tax point of view. So from a tax perspective, do you see LPs preferring a feeder to enter India or invest directly in Indian funds? And for pure offshore funds, do you see a jurisdiction preference through which to invest in India?
So obviously, you have to see this in the context of generally fund structures have evolved in the last couple of years. For a lot of India dedicated funds, as we know, there is an increasing preference to look at an Indian alternative investment fund as the preferred fund structure. And increasingly, we are seeing a lot of the funds which have historically done offshore funds move in that direction. And that's obviously because of a lot of the tax treaty benefits going away, a lot of transparency, which makes disclosure of offshore structures pretty transparent from an Indian tax perspective. And all of that in sum has resulted in moving onshore. But having said that, unfortunately, the tax law has not kept complete pace with that trend. And what we do is, still amongst a lot of LPs, maybe with the exclusion of DFIs, maybe going forward, given the exemption for some sectors, maybe sovereign funds, wanting to continue to invest in offshore structures, and hence the need for a feeder fund. Because primarily there are two constraints. Foreign LPs do not want to be subjected to any Indian scrutiny. At least those of who want to remain ring fenced from an Indian tax administration litigation standpoint want to be able to be separated from the Indian fund, because there is as yet, despite a lot of representations that have already been made, no exemption that is available today for a foreign LP to from filing a tax return or obtaining a tax ID and the like. So that's obviously driving a lot of LPs to continue to prefer an offshore fund, and therefore the need for a feeder fund in a lot of Indian AIF structures. I would say two more things from a perspective to answer your second question on offshore fund, that depending on the sector you're invested in, we are continuing to see an interest in having pure offshore funds based on the kind of investment strategy that you may adopt. So for instance, there are funds that let's say have a pipe strategy, have a balance strategy where they're investing in a combination of listed and unlisted. Or if you're investing, let's say, in a lot of VC, early stage tech oriented consumer tech kind of businesses, then the limitations today that are there in Indian AIF regulation and the Indian broader regulatory framework of what kind of investments you can make using an AIF, or what level of overseas investments you can make using an AIF, still drive a lot of these funds to be set up overseas and remain overseas. And so to that extent, you'll only see the Indian capital being raised in an Indian AIF and not all of the fund being commingled in an Indian AIF. And that's where it becomes important on what the right structure for the offshore fund is. And as we know there, a couple of things that have again happened from an overall Indian landscape perspective and global tax landscape perspective as well, that we are clearly in an Indian general anti-avoidance regime. And globally as well, most countries have signed up, and multilateral instrument has become effective in India, especially from 1 April 2020. And that makes it extremely critical and important to ensure that the overseas structure that you put in place is fairly robust and has a good non-tax commercial motive for the manner in which it is set up. And that's where, while historically there has been and continues to be so a preference to have Mauritius-based fund structures, we are increasingly seeing inquiries for people who want to set up a fund structure, let's say in an alternative jurisdiction like Singapore, which as some of you or all of you may know, has recently come up with a fund-specific legislation called the Variable Capital Company Structure, which is designed for funds and based on a lot of feedback that funds have given. So as far as offshore jurisdiction is concerned, I would really say that apart from Mauritius, which continues to be the predominant choice amongst many fund managers, we're seeing a fair bit of interest and even some movement in favor of Singapore. But that's the way I would sort of summarize your two questions.
Sure. Thank you. So thanks, Subbu. So while we were talking, we had posed the live poll in which the question was asked. So I'm just sharing the results. In times to come, how do you see commercial negotiations shaping between LPs and GPs? So 66% of the attendees feel that the fees, expenses, and carry will be negotiated more than the present or current times. 34% of the attendees have said that they don't think there is going to be any change from the current position.
Yeah.
Okay. So moving ahead, so let's jump to the next topic for our discussion. Now coming to the regulatory regime for the AIFs in India. So Tejesh, you interact the most with SEBI on almost on a daily basis. So what shift have you seen recently? Any issues you would like to highlight? And what can the regulator do better to support the fund's activity in challenging times, which are likely to be here?
Hey, sure. Thanks, Suneet. See, look, SEBI you would have seen that SEBI's intent behind the standardization of the PPM and enhanced disclosures, as you would have noted that notification was out 2 months back. That intent is all pretty good, and IVCA has also done a fair bit of work on that front. However, the problem was under regulation previously, and the problem is over regulation right now, right? So somehow we have not been able to settle somewhere in between, which would have been ideally the sweet spot, right? And that is the problem which Sudhir was identifying, and I agree with him that if the government is closing a few doors, right? If they are closing the doors for Chinese investors and are putting approvals in place, I think there is a huge amount of quality institutional capital which is available in the country, right? We have got pension funds, we have got insurance companies, we have got banks, we have got SEBI, and these are all allowed to invest in category 1 and category 2 alternative investment funds. But I think that's not something which is happening with the desired pace as of now, and I totally agree with Sudhir that that's something which is the desirable thing if the Indian fund industry has to thrive in times to come and more challenging times to come. Now, if you see, there are various prohibitive clauses which SEBI has put under the notification, right? Now, SEBI has prohibited inclusion of any clauses and side letters which provide more favorable terms on LPs on account of any indemnifications or contributor givebacks, right? On account of any post-term liabilities which can come on the fund on account of legal or tax aspects. Right now, SEBI also says that you can't put any clause in your side letter which can have a material adverse effect on any of the other LPs in the fund or economic effect on any other LPs in the fund, right? So the intent is all good, but then, as I said, again, it poses a lot of practical issues for the GPs, right? For instance, if you have even one LP in the fund, amount of factors unique to that LP, right? Because it's, say, for example, listed company was an investor in your fund, and they say that from an audit point of view, they can't keep their books open more than 1 year period, right? So if you are given them the monies back, they can't be giving you the monies back on account of any clawback requirement which GPs have post their term, say, for more than a 1 year time period, or they would have a cap of 5% or 10% beyond which they are not going to return the monies back. Now, if I go by the current law and what SEBI has been insisting all the fund, which is a very impractical desire, I would rather say, is that you should have a same contributor give back clause, same indemnification clause for all the LPs in the fund, be it for LP, be it a 50 crore LP or a 100 crore LP. So that practically really doesn't, because it can really backfire the investment managers, right? Because if they have returned the monies and if there is a spillover, and do you mean like they have to pay out of their own pockets to vis-a-vis all the LPs in the fund? So if 10% is not being prescribed for all LPs as a give back cap, or 1 year as a time duration has been prescribed, but Indian laws may go for 3 years for non-tax liabilities and 7+ years for tax liabilities, the man out of their own pockets. So we have has agreed. Then if there is a spillover on account of that investor, it really doesn't make practical sense, and it can really issue because one, we started facing theoretical issues on, say, compensatory contributions. So regulator wants a set formula that how you charge compensatory contribution should not be at the discretion of the GPs. Now, how is that practically possible, right? You can't have a straitjacket formula today that somebody is coming in the subsequent closing after a year or 2 years. So the manager is not going to exercise any discretion because there is a conflict what SEBI sees that if manager, say, waives that compensatory contribution or reduces it, then it can harm the first closing investor. But then you yourself have government investors, there are other investors who by law, who by their internal charters can't pay a compensatory contribution. And we all know that how valuations can work. It's only at the time of exit you can really see that are you able to fetch that price or not. So asking a LP a year later that out of like a dollar money you are putting, you also pay 15 basis points more on account of compensatory contribution to compensate the previous guys, the fund managers will not be able to raise money. So all these are like very, very, very practical aspects which we are trying to convince SEBI that we, in a regulatory overdrive, we can't impact the fundraising by the GPs. That's the simple point we are trying to make. So yes, as I said, the practicality is missing a bit, and everybody is trying hard in the industry to convince the regulators to also appreciate the practical standpoint. We are all in favor of regulations, but as I said, like excess of anything is bad, and the new approvals from the regulators, they are taking the eternity to come. They are taking 4 months, 6 months, 7 months, and this is not something which will help the ecosystem to thrive. And more challenging times we see, I think the regulator has to really expedite the approvals, and be it RBI with respect to banks or be it IRDA with respect to insurance companies. The classic questions we face that if insurance company is an investor in my fund can't make investment overseas, and multiple insurance companies have their interpretations that, okay, whether the fund will be allowed to invest overseas or not. I think I again come back to Sudhir's point there that the regulators have to create a conducive regime. So if the offshore money is getting restricted, then you have to open up the domestic pools of capital. So sometimes if SEBI starts comparing AIFs with the mutual funds, which are more retail vehicles, that's not going to help the cause at all. So I think these are all sophisticated investors you have in the funds, and a few things should be best left to the wisdom of LPs and GPs and may not get into overt regulation. Yeah.
Okay. So thanks, Tejesh, for your views. And we'll also share the poll results, which also echo the views in the industry. I think they are almost matching. So I'll just end the polling. Just give me a couple of seconds. I'll share the results. Yeah. So 70% of the attendees feel that it is a good step that SEBI has taken to standardize the PPM, but not all aspects have been articulated with the necessary clarity. That's a very significant portion of attendees we're talking about.
Yeah, not surprised. Yeah.
Absolutely. Yeah. And 14% feel it's impractical. That's okay. It's a small percentage. Okay. All right. So, coming to our questions. So my next question is to you, Subbu. Do you see the new fund structures emerging to mitigate the indirect taxes on management fee levy, since that would be a cost to the fund or to the investment manager if negotiated by the LPs? And do you see any liberalizations expected from tax perspective, which will be conducive to domestic as well as offshore funds?
Sure. I'll talk about both the points, Suneet. So essentially, when you look at indirect tax, so that everybody is on the same page, obviously this is the issue of an onshore AIF when it is paying management fee to an Indian investment manager. There is a GST of 18% that is charged on the management fee, and that given that management fee per se is a dead cost. Any renegotiation or negotiation of the overall management fee, including GST, has a direct impact on the top line of the fund manager, because if he has to give a corresponding benefit to the investor, then that means that he is essentially dipping into his top line to make that good. So I think obviously from an industry perspective, there has been one of the top asks is that still remains unresolved is this pass-through treatment from an indirect tax perspective, that to the extent that a fund has foreign LPs, there should be no GST charged through whatever mechanism, either a rebate mechanism or an exemption mechanism, so that there is no export of tax on the services that are provided as it relates to foreign capital. But that unfortunately has not yet been addressed, and that's on the second point from a tax liberalization standpoint also is really the top ask from the industry. So as a result, what we have seen is really a couple of things. One, of course, we have this what has now been implemented in few funds, a structure where you minimize or reduce the management fee to an extent by passing on what would have otherwise been viewed as management expenses or the manager's expenses by putting some staff directly in the fund. And therefore, reducing the management fee to the same extent, which effectively or indirectly helps you save GST. So that's of course one structure that we see in the market, has been done by some funds. Obviously, whether that passes muster or not is something that time will tell. And of course, the other option, which increasingly is getting clearer and clearer, thanks to the regulators' actions, is the option of putting the fund itself in the International Financial Services Center in GIFT City to mitigate GST, because that gives you a clean zero-rated exemption on the management fee. So these are two alternative structures. The latter, of course, has its own nuances and challenges to implement. So we're not seeing a broad-based pickup, but certainly some interest in moving in that direction that we are seeing in the market. I think on your second point, broader from a tax liberalization standpoint, of course, the industry has many asks. Purely from a PVC perspective, one of the big asks that we are asking, and Sudhir made the point on activating domestic investment pools. Apart from some of the enabling frameworks, which actually unfortunately reside in the tax law, to enable some of these capital pools to be released for investing in PVC asset class. I think the big ask that is there today is that we suffer from a huge disparity in tax outcome of investing in India for domestic investors between investing in listed and investing in unlisted. And today, if I look at any rational investor, he is going to look at what his net of tax outcome is from a asset class investment strategy perspective. And that is one thing that the industry has been speaking with the government to bring some level of parity on what an investment in an unlisted company results in from a tax perspective, which today is 20% long-term gain tax plus surcharges, and that to the highest level of surcharges that are possible, versus listed market, which always remains incentivized relative to investing in unlisted. So whether you're looking at early stage investing, VC investing, growth investing, or even control type transactions, across the board, you have investors in the domestic market who have the capital, want to deploy the capital, but suffer more taxes than investing in listed markets. And in today's time, when there is opportunity aplenty everywhere, that allocation of capital and the tax consequences of it become quite critical in that allocation strategies. That's one ask, certainly from an industry standpoint, which now is a better time than any for the government to seriously consider and implement. And the second big ask is to, again, from a capital gain computation perspective, given that in this sector, management fee is really the big driver to realize gains, is to get a tax deduction for those expenses while determining the gain. And if these two are done apart from the GST issue, then it will be a big win, I think, for this sector overall.
Okay, all right. So thanks, Subbu, for your insights. So actually, I'll come to you in a couple of minutes. Before that, I'll just ask a question to Sudhir here. Sudhir, you were a pure FDI vehicle until recently when you raised an Indian AIF. Can you highlight 3 top issues or challenges that, according to you, need to be looked into by SEBI for making AIF framework more manager or sponsor friendly?
So I may have not 3 but 6 points, if you permit me.
Sure.
I think first is purely at a conceptual framework level. What's the role which I think environment can play, regulatory environment, is to increase and some of this may have been repeated earlier, but permit me in a brief to repeat that again. There is 3 large contiguous markets for private equity VC in the world, which are US, China, and India. And India is the 3rd largest. However, India is capital deficient and the others are not. So effectively, the capital deficiency arises partially out of the fact that Indian capital is not unable to invest or does not want to invest due to flaws which are there in the taxation and other areas. So, and to me, the first thing should be regulation should enable global and Indian capital to be residing in India. The manager to reside in India. To me, this whole issue of POEM and finding legal ways and means, okay, of justifying a structure outside the country is the most ridiculous thing I've ever. I'm not a legal guy, okay, but we all know that if the manager is residing in India, decisions are taken in India. I am saying this very openly, right? So the issue is, if international capital comes in, let the manager be resident in India. By the way, AIF was a very good structure. I mean, our first AIF fund was raised in 2013, by the way. We pounced on it because we thought it will enable us to stay in India, which hopefully it has. Now the question is AIF being used to garner rupee capital or to garner international capital? Actually, the bulk of capital which AIF gets is not rupee capital, it's international capital. And it is 95% international capital, not rupee capital. So that must be rectified overall, and then enabling decisions to be taken in India where there's no need for pooling outside the country. Why should there be a need to pool outside the country? Okay, I think that's a big issue. We have to still solve it, and we must solve it as soon as possible, which will enable capital formation for private enterprise to be happening in India. Second thing is that if you look at, and these are small issues, but they're big. I think, GST has already been covered, very important. Rupee capital is at disadvantage, very important. There is an issue of GPs not in the AIF being able to take returns until the full capital with hurdle rate to the LPs is returned. That's an LP-GP matter. It's not a regulatory matter that we don't have to do outside the country. Okay. Overall, the structures are very complex. I truly believe that this whole effort on structuring PPM should not be there. Why should it be there? If a GP does not know how to write a PPM, right, then there are ways and means to go and learn how to write a PPM. Why should a regulator structure a PPM? Why should, by the way, writing a good PPM is a strategic and a competitive edge, okay? And terms are competitive edge in the market space. And LPs and GPs can take care of it overall. So to my mind, one of the most important points is, I think there's a speed and agility issue also which is required. We were wanting to open an office in the US, and it's such a pleasure that at the end of the day, there is a publicly stated document which says you will get a response in 15 days after you apply. There's a list of things which were written, and it's all available. We followed that list. And by the way, we got a response that here is your approval. You met the whole thing, and 15 days, when there are these things you do, and you've got the approval. I think it's high time now that issues like, if fund managers like us submit an AIF proposal, there must be a timeline for approval. There must be a timeline for not approving. Okay, it cannot be endless. We must also go into things like, if AIFs have to invest outside the country, which is allowed, by the way, up to 25%, etc., right? It cannot take 4 months. Private equity works on agility and speed also. So any structure which you have to separate it in such a way that dollar money goes in, because we don't know when the rupee money will go into the outside entity where we are investing within the laws of the land as such. So to my mind, these are very, very important issues. The bigger issues which we would like to see is time commitments and speed commitments, which are crucial to our success, and more rupee capital coming in, and this whole minor issues left to GP and LP. Okay, yeah, these are my 6 points. I think you're on mute.
Yes, I was saying well noted, Sudhir. Thanks for that. Moving on to Ashley, would you see pure offshore players like yours setting up an India-based AIF. Quite a few have done it in recent times. Currently, as an offshore fund investing in India, do you find anything challenging with the FDI investment norms which you would like to see a change in or being really liberalized by the government of SEBI?
Sure. So, actually, I just want to reiterate the things that, the previous panelists have said. I think, if you're a fund that is focused on investing in India, there should be absolutely no reason for you to have pooling vehicles outside, right? You need to have an enabling regulation and legislations to allow you to make those investments directly. Our job should not be to complicate structures. I know, there was a conversation we were having about, how can you do a certain fund structure that was being contemplated. And at the end of the day, there were 9 entities that needed to be set up to sort of get everything done. I mean, that's not the business we should be in, right? Our business is, yes, you need to interact with investors. We need to make investments. And I know we have, few of the panelists here who enjoy or have benefited from these structures are complicated. But frankly, I don't think it's in their interest as well. I think, we need to have a simplified regime. You can't have a regulator. On one hand, initially there were no regulations when we had VCF, it was or FBCI sort of mode where you could come in as a foreign investor, or the VCF, which is very, very loose, and you can't swing to the other side of the pendulum where you're dictating what an LP and a GP conversation should be at. These are sophisticated investors who invest. You need to have the ability to that a GP can have that conversation directly with them. And ultimately, even if there is foreign capital today, and I agree, Sudhir said 90-95% of the money is foreign capital. In every other part of the world, that foreign capital comes in directly into the entity. You don't have a pooling vehicle outside. You need to create a pooling vehicle outside to shield those investors, to address some of their issues around, will they be required to file tax returns, etc. Frankly, I think we have stuck to doing sort of an offshore structure because we do not have any Indian LPs. So there was no need for ChrysCapital or your funds where you don't have a domestic LP to be regulated in India. In my mind, would an AI structure in India or a 9A structure or even an IFSC structure be ideal? Yes. But there are so many issues with each of these that people choose the lesser of the two evils. I know your question was directed around what are the challenges around FDI. Yes, there are challenges around FDI. There are sectoral issues. There are, if you're investing in listed, in small cap companies, there's a limit even if you come into an FPI of owning only a 10% stake. There are multiple issues. But frankly, those issues are much lesser than what we see in terms of the domestic regulations on that side of the table. And, the endeavor needs to be to clear that up. I think you need to be, as a country, you need to attract both foreign investors as well as domestic investors into a regime that makes sense. And we don't have to reinvent the wheel as a country. This is we're not the first ones to bring in private equity or capital into the country. It's quite easy. You just read the regulations of other countries, understand the norms that are being set, create norms around who is a credible investor. And once you have a credible investor, you don't need to get into the protection mode of those credible investors. We are not mutual funds. We are not dealing with retail investors. And maybe you implement the regulation saying that the minimum size should be X, or how do you make sure your LP is an accredited investor and therefore has the ability to have that level of negotiations with a GP. And I think that is the more important aspect in terms of the overall regulation. Obviously, on the tax side, is there parity between, frankly, foreign investors actually have, a beneficial tax treatment in quite a few cases versus domestic investors today. There's the GST, so there are multiple reasons why people are moving the nerve centers out of India. And it's actually contributing to the economies of other nations as opposed to India itself, right? Because it's the administrator, the lawyers, the accountants, all of those, you're creating a stream of activities outside India versus doing it in India. So the amount of, if you look at the overall taxes lost because of forcing people to do it in a particular way and effectively they're moving out of India, I think that is the cost benefit that frankly the nation needs. And ultimately, if a lot of that capital is foreign capital today, how do you get it, straight away as opposed to through a complicated pool structure? I think that is the one point I think that I know IVCA has been taking up as the number one issue to sort of work with the government on that and educate them and try and alleviate some of those issues.
Okay, sure. Thanks, Ashley. Neha, I have one question for you. Given your position as a multilateral DFI, when you tend to speak with your counterparts in the other parts of the world, what kind of sense that they get from you in terms of how they see India, the Indian laws, Indian regulations so far as the fund regulations is concerned? Do they complain? Do they say that okay, it's there in Singapore, how come it's not there in India, or it's there in UK, how come it's not there in India? What kind of sense you generally get to hear from your counterparts in other offices?
Sure. So I think in terms of most of the offshore investors have traditionally used Mauritius as a route to enter or invest into India. And in recent times, people have used Singapore as well. US LPs have used Cayman. And recently, some LPs have started coming in, largely DFIs and multilateral organizations have started coming in directly into India. I think one broad brush comment is the ease or the quickness with which a lot of these, with Sudhir and Ashley both spoke about, setting up entities, getting sort of responses from the regulator is so much easier in these other jurisdictions versus India. That's one. I think the second comment always is around taxes, or the uncertainty of taxation, the changes in taxation which happened over the last decade, and therefore there's so much of uncertainty around taxation. Recent times we had GST which came in, and there's now another sort of question on who should bear GST, whether it's the GP or the LP, whether it's fair, what is not fair. I think these two or three, so one is quickness and response times. The compliance sort of burden on fund managers is much higher, even from an LP perspective. And the second is taxation. On taxation, I think one more issue which LPs generally shy away from, and therefore are not willing to come into funds directly into India, is the entire filing of their income tax returns in India. So most LPs are not okay because you don't want to get into regulatory issues or taxation issues. There's so much of uncertainty and so much of litigation in India that most LPs want to stay away, and therefore want the pooling to happen outside of India, whether it's any of these jurisdictions that we talked about or some others.
And Sumit, can I just add one point?
Sure.
I just step back and say, last 6-7 years, India has absorbed about $120-140 billion worth of capital, private equity and VC. And again, crystal ball, very dangerous, but in today's situation, I believe that next 6 to 7 years, it is likely to be $200, $225, $250 billion, right? Now, are we satisfied with that? One way to look at it is, hey, it's going to double, okay? But if factories have to move out of China, if large enterprises are being developed from India, okay, then can India absorb in the same time frame $500 billion worth of capital or $700 billion worth of capital? That's, to me, is the real question. Once we get stuck into those small issues, right, this $250 billion, $200 billion will barely reach. Once we solve the big issues very fast, okay, today is the time to solve them, because I personally believe that India has the opportunity in the next 6 to 7 years, 8 years, to absorb nothing less than $500 billion to $750 billion worth of capital and go to something like 2.5-3% of GDP. Okay. If we don't, we will miss that opportunity.
Point well taken, Sudhir. Thanks for that. So we have already overshot our scheduled time for the webinar. So there is not enough time for us to do Q&A. There's just one question, if Subbu can answer. There's a question being asked by one of the attendees that is the time opportune to look at GIFT City in terms of the existing framework, and what kind of views you can share from a tax point of view?
No, certainly, as I said earlier, there's been a fair bit of, there were a lot of issues with the gift framework to enable funds to be formed in gift that have been progressively clarified. Of course, I know before we moved into the, just around the time a lot of the clarifications came through was election time, and people wanted to see how, what happens from a political dispensation standpoint, because there is an expectation, at least in the broader financial services sector, that we will hopefully see IFSCs come up, let's say, even in a city like Bombay, as an example, and therefore, have clarity on matters before they can take a final call. But to answer this question, certainly the regulations, as I said, have been clarified to a great extent. I would say, there were 10 issues earlier. There probably remain only one or a couple of issues to be dealt with. There is an approval process that one needs to go through, apart from just getting the entity set up and getting SEBI registration for it. But I think, at least in conversations that we've had, I think some of the investors also want to see how the unified regulator and the related aspects play out. And that is something which is still awaited. While the notifications and the regulation for it is already out, we've still not seen the unified regulator being set up. So I think we should see more traction in gift as an option in times to come, for sure.
Okay. Thanks. So there are a few other questions, but I think most of the questions have already been addressed in our panel discussion. But there's one question that I think we can still take. That is on the MAC clause, the material adverse impact. So I would like to get a sense from Sudhir as well as Ashley, what they think in terms of their discussions with the portfolio companies and the management teams there. Whether you have looked at the MAC clause being invoked in respect of your investments, because of the current times, they wouldn't be able to fulfill some of those covenants that would have agreed on the business plans, so on and so forth. So yeah, Ashley, maybe you can start with you and then we'll jump to Sudhir.
Sure. So I think, the lawyers, you guys are better equipped to answer this question, but our limited understanding is that, look, first of all, under Indian normal contract law, if you don't have a specific MAC clause in the agreement, then you can't really invoke it. You do have the concept of frustration, and which is basically if it is impossible to complete to complete your end of the contract, then you can try and pursue some legal remedies around that. I think this is it's way too complicated right now. We are seeing, our advice to portfolio companies is focus on the things that you have control on. Obviously, they and have conversations with people. So whether it's with employees, whether it's with landlords, whether it is with suppliers, I think the conversation has to be practical, where you have that conversation saying, look, we have an issue. We are transparent about it. This is the way we think we can circumvent it. Either it means deferring, decisions, deferring payments, staggering it. It may be better to have, in our mind at least, practically to sit down and have those conversations, because you typically don't have these MAC clauses. Now, if you have a MAC clause and the world has changed, and it has the word pandemic in the MAC clause, then you certainly can enforce it. I think it's frankly it's going to be difficult, and it's not too bad to have that conversation, because if you ultimately sit down with the other party, whether it's a landlord or other supplier or whatever, then they want your survival to be something that's important. I mean, that helps them survive, right? So I think that's the concept you need to have with them, and be practical and pragmatic. And if you're able to do it, I think figure out what's more critical, what's less critical, focus on the more critical stuff, and try and navigate through the problem this way.
Yeah, sure. Sudhir, your thoughts on this point, if you can just add.
You're on mute, Sudhir.
Yeah, you're on mute.
Can you hear me?
Yeah. Sure.
Yeah. So I'm, totally agree with Ashley, and it's good to be the second one to answer. Completely agree, no question. There are issues we can solve together with the entrepreneur. and that's the the crux of the matter right now. So case to case, but it has to be done together. This is too serious for all these things right now.
No, absolutely. I think just to add my 2 cents, because you can, like, lawyers can spend like hours discussing this particular point, and I think we have next 2 webinars coming on, and I'm sure like 1/4 of the time is going to be devoted to how the MEs are going to work, how force majeure is going to act, and how doctrine of frustration under Section 56 of Indian Contract Act will come in play. But I think, to cut the long story short, I think I agree with what Ashley and what Sudhir has stated. There is no point getting into litigation. I think the relationship has to be such in which you are sitting on table across with these guys and you are figuring out a solution. So ideally things shouldn't get into litigation. Lawyers, yes, absolutely would have worded the clauses the way they would have wanted. But yeah, I think it's more like sort of in situation like this, it has to be more sort of a coordinated call which will have to be taken. So it's in the interest of the fund as well as the portfolio entity. I would see it as.
Okay. All right. Thanks, Tejesh. I think with this, I'll just make some few closing remarks and we can end this webinar. Thanks, gentlemen, and Neha, for your inputs and for valuable time. So on behalf of IVCA and IC Universal Legal, I would like to thank all the panel members for taking the time out and sharing valuable insights. The discussion was truly enriching. Many thanks to all the attendees for your precious time. We will see you again on April 22nd, next Wednesday at 3 p.m. for the next webinar on managing deal flows and portfolio selection during COVID times, where we will have the senior folks from Everstone, SL, Microsoft India, Fireside Ventures, PwC, and IC Universal Legal sharing their insights. So do register for the same. Wishing you all a healthy and safe times ahead. Thank you very much.
Thank you.
Thank
Bye-bye.
you.
Thank you. Thanks.
Thank you so much.
Thank you, everybody.
Bye.
Thanks. Bye.